Okay, this is a book summary and book review on the Little Book on Legal Writing by Alan Dworsky, in particular, Chapter 11, Authority. We're just going through the main points, mainly knocking these out. 1. Always cite authority for your legal arguments. Next, use mandatory authority as your foundation and other authority to fill in gaps. Constitutions, statutes, cases, and rules have the force of law. Next, don't cite a case for a rule that comes directly out of a statute. When a statute is your primary authority, it is the strongest citation you can give. That's why the case citation in the following example is unnecessary. We're not going to go through that example. Next, if a federal case applied state law, tell which state's law. If a federal district court is in Texas, it doesn't mean the court will always apply Texas law on issues not controlled by federal law. Principles of conflicts of law determine what state's law a federal court will apply. Next, cases, unlike fine wines, don't necessarily improve with age. Although our judicial system is based on the principle of stare decisis, the law is always changing. Sometimes a court overturns an old rule with a single stroke. Other times a court will gradually chip away at an old rule until there's nothing left of it. That's why an old case that hasn't been overruled isn't necessarily a good one. You must shepherdize the case and track it to the present to see how the courts have treated it. Next, a case may be helpful even though the results go against you. Now this is interesting, so we're going to read it. Suppose you want to ask a court to set aside a settlement your client agreed to because your client entered into it by mistake. In your research, you find 20 cases in which the court refused such a request and none in which the court granted it. No doubt about it, things look bad, but it's not over yet. Let's see where this goes. Legal arguments are not evaluated by counting cases. The number of cases going against the party in your client's position does show a tendency of the court. It does not determine the results in your case. How interesting. You may be able to argue that something in your case distinguishes it from others and that under the rule applied in those cases, the results should be different. You may even find helpful statements in other cases, such as, if the circumstances in this case were X, we might have reached a different result. If you have X circumstances in your case, you're in great shape. Next, parenthetical phrases are for the facts of unimportant cases. Don't put the facts of an important case in parentheses. Parentheses signal the reader that what's inside them is incidental. Next, don't cite or quote headnotes. Headnotes are one-paragraph summaries at the beginning of cases. They are supplied by the publisher as a convenience to the reader. Because they are not written by the court, they're not part of the opinion. Use them as a research tool. Don't rely on them as an authority. Next, cite as many cases as you need and no more. Look at how good that is. No more. How fantastic. You got to save work. Next. Okay, my video got interrupted by an alarm, so this is again part 2 of chapter 11, Authority. So I'm just going to start off where the video left off before the alarm. Cite as many cases as you need to and no more. Next, it's hard to tell whether you found all the relevant authority. The second most commonly asked question by students working on a memo or a brief is, how do I know when I've done enough research? Hard question. Interesting. Often, you can tell you found everything because you reached a closed loop where all the cases refer to one another. Other times, you know you're finished because you simply run out of time. I run out of time all the time. Oh my gosh. Other times, if neither of these things happen, it's reasonable to quit after you've carefully and thoroughly used the research techniques you learned in your legal research course and found authority that seems to cover your issue. Next, this is the last one, treat factors and requirements differently. Statutes and common law rules are often divided into parts. These parts are called variously factors, requirements, elements, tests, criteria, etc. You must consistently call them whatever the statute or case calls them, even if it's, what were they thinking? Prongs. You must also pay close attention to the meanings of these different words. There's a critical difference between a factor and a requirement or element. A factor must be considered, but a party may do poorly under it still win if the party does well under the other factors. A requirement or element, on the other hand, must be met or the party loses, regardless of how well the party meets other requirements. And ladies and gentlemen, that is the end of Chapter 11, Authority. Remember to kiss that like button with your finger, kiss that subscribe button with your finger, and if you're really interested, go to the Miyakizilla Patreon page and support the Miyakizilla project. All right, thanks, bye.